Hello, everybody. So welcome back to my English Law channel. So I'm carrying on with homicide, looking at various defences, such as diminished responsibility. And this can come from having an abnormal mental function. And I was saying yesterday how this must arise from a recognised mental condition. Now, if you go back decades, the law was different, and this had to be an inherent condition, but didn't have to be from a particular list. These days, it's changed, so it's not as flexible as it used to be. The defendant can't say that he's a very covetous person. That won't be a defence, or things like that. Or he had less self-control than most people because he was worried about his daughter's health or something like that. So, and the psychiatric condition cited has to be something we found in the Diagnostic and Statistical Manual of Mental Disorders or the International Classification of Diseases. This is an illustrative, not an exhaustive list. It could be arrested development. It could be or mental, well, I have to say it, retardation. It could be someone that was suffering from depression, as per Gittins, 1984, bipolar disorder, as per Inglis, 2010. The person could be a paranoid schizophrenic, as in Sutcliffe, 1981. So that's Peter Sutcliffe, the Yorkshire Ripper, who killed about 24 women in northern England in the late 1970s. The person could be suffering from brain damage, or the person could be a psychopath, as in Byrne, 1960, paranoid personality disorder, as in Martin Anthony, 2001. That's the farmer Tony Martin who shot dead a burglar. Postnatal depression, as per Reynolds, 1988. All right, there are other cases like a soldier in Afghanistan who finished off a wounded Talib fighter, and he was taking some medication which may have unbalanced his mind, or who was Harris. This is about 1996, a doctor who murdered his wife who's on some medication. All right, so the law will require expert witnesses to testify if this is a contentious thing. Brett in 2014 was a case about that. So there's a procedural issue about this defence. So if medical evidence is evinced by the defence, then the prosecution will probably try and find their own medical expert to say, no, that's not the case. So anyway, so the battered wife syndrome, that's by Alawalia and or indeed Hobson, 1998. Alawalia is what really put that into English law. Premenstrual syndrome, Smith-Sandy, 1982 is another example of it. Okay, so attention deficit hyperactivity disorder is not a reason to say that you have any diminished responsibility. Okay, so let's look at how alcohol can play a role here. Now, previously the law said there's different from a debauch one evening and from being a permanent alcoholic. So if you're drunk just that night, that's not a medical condition. That was decided in Fenton 1975, and therefore it shan't grant you a defence. Dowds 2012 was a case where the Court of Appeal said that if you're drunk because you're permanently drunk or whatever, then or just drunk on that occasion, then that's not diminished responsibility. So, but remember, this abnormal mental function doesn't have to be the only reason for killing the person. It provides an explanation. It can be part of the totality of explanations. So someone could kill another due to the combination of inebriation and suffering a recognised mental condition, and that might be a defence. Deachman was a case about that. That was in 2003. So that overturned Egan, 1992. In R against K 2017, the defendant was a schizophrenic, and he couldn't prove that the schizophrenia is actually what caused him to kill someone. It might have been because he was drunk out of his tiny little mind. Schizophrenic can't always rely on schizophrenia to be the reason. That might not be the trigger for killing someone. Perhaps it was the fact that he was in a crapulous state at the time. All right. Now, there is an exception to those people who are permanently alcoholics. So, under the old law, an alcoholic could say, well, this is a permanent situation, so I have a defence here. And that operated in Wood 2009, Stewart 2009. So now alcoholism is recognised as a medical condition. person cannot control their yearning for alcohol, because they have the delirium tremens if they don't get it. So they're not able to control themselves as much as anybody else, and their mind doesn't function properly. They can't form proper judgments. So the defendant here, K, could have used this defence to show that he had this psychotic episode, and that arose from a concatenation of schizophrenia and his dipsomania. Anyway, it didn't work in this particular case. So Wood is a case a bit like that. There was an itinerant, a gentleman of the roads who was a dipsomaniac, and whilst in a drunken stupor, he killed another homeless man who'd made some gay approach to him. So the judge, he directed the jury, but he gave them the wrong idea that the defendant drinking alcohol had to be completely involuntary for this to be an internal pathology. So the defendant was then granted an appeal, and then he won his appeal. There was misdirection by the judge in the original trial. So the President of the Queen's Bench Division said that the judge's proposition had been erroneous. The judge had said, unless every drink consumed that day by the appellant was involuntary, his alcohol dependency syndrome was to be disregarded. Well, that was wrong. Okay, but remember that the dipsomania has to be the reason for the killing. This is the new law. Because yes, you might well be a permanent alcoholic, but that might not be why you killed the person. Might be another reason. Or indeed participating in a killing where several people actually killed the victim. So it had to be that the defendant's mind was so impaired that he did not properly comprehend what he was doing, and he suffered from a dearth of self-control. So a psychopath would not be able to use this defence, because even if they weren't drunk, they would not have these abilities. They don't have ordinary cognitive abilities. So the Coroners and Justice Act 2009, if you look at section 52B, says that the explanation will be provided if it causes or is a significant contributory factor in causing D to carry out the conduct, close quotation. So does that mean that's the reason for the killing? Well, that's up to the jury to decide, because there could be several factors behind the slaying. Depression, intoxication, as in Gittins, could be dipsomania, like as in Wood. So, okay, and remember that the mental disorder, it has to substantially impair the defendant. As the expression used, substantially impair the functioning of mind. So what does substantially mean? Well, it's got to be at least significant. Golds 2014, the court said it's got to be something. The Court of Appeal said it's got to be something weighty. Mean that the person's mental abnormality must have a really major effect on the person's ability, or rather inability, to control himself. Now, it's up to the jury to decide, is it serious enough or not? So they will vote on that one. So the Supreme Court said that the Court of Appeal's definition in Golds was correct. They denied Golds' appeal, saying that diminished responsibility is substantial impairment means this: something while short of total impairment is nevertheless significant and appreciable. Okay, so that's enough at the moment. We might go on to involuntary manslaughter. Toodaloo.